Hello, my name is Carl Jensen. I'm speaking from the law office of Carl Jensen in Great Falls, Montana. This is an educational video. It is not legal advice. It is not intended to be legal advice. It does not create any attorney-client privilege or relationship. Please consult with an attorney before making any decisions that might be related to this. And finally, I am not responsible for any downstream repercussions from this video. It's merely for educational purposes only. Clearly, we're talking about Montana law and not the law in any other state or jurisdiction, and as it applies here. So many states are very different in their interpretation of things. That being said, let's begin. We're going to talk about another affirmative defense. This one is called good character. It's essentially that you're saying to the jury, I'm such a great person, individual, that I would not commit this kind of a crime. I've had clients often come up with this saying, I've got a bunch of people say, great guy, I'm not willing to do this or capable of doing this, I'm not have the temperament for it. In general, that's a bad idea, and I'll get to why it is. But to start with, everyone really at some level has some kind of tipping point or potential to do all sorts of things. And while in most circumstances you wouldn't, saying there's no way you could do that is already a problem just in the minds of most jurors. But secondly is if you get up there and say, I've got such a great character, then the prosecution can get up and talk about what a horrible person you are. In terms of they find anybody out there that can say bad things about you. You've got any kind of ever charge out there, even if it's not a conviction of a similar nature. Things like that can be, basically anything goes. So normally in a trial, it's regarding the particular facts, whether you did something or not. With a good character, you're opening the door to just about everything, because you're saying, I didn't do this because of my character. And I'll give you a perfect example of this. So a while back, I had a client that wanted to do a good character defense, and I went about, contacted all the witnesses that he listed, had statements taken from them, was getting all ready to go for it, and I asked my client repeatedly, is there anything out there that would be concerning, that a jury might think, well, I don't really care for that, and think badly about you? And my client, of course, insisted, no, there isn't. And what happened in that case is the week before trial, the prosecution's investigators were backtracking a bunch of things, and they got really excited because they found something that was really damning in my client's background, something that would really have hurt his case. And they, of course, divulged that to me because they're obligated to do that. And I had a long conversation with my client who was surprised they found out about it. And then I had to call all those witnesses and tell them I'm not calling them. I couldn't explain really why, but it certainly raised a bunch of eyebrows. So in general terms, good character is probably a very bad thing to do as a defense. There's just about everybody probably has a skeleton somewhere in their closet of some kind, and if not, they have some kind of enemy that doesn't like them, whether it's an ex-partner, male, female, whatever, ex-spouse, ex-employer. There's almost always somebody that you don't get along with, and there unfortunately are people that are willing to say really bad things about an individual just to watch them burn in flames. It's just a natural part of life. So while there is the affirmative defense, and again, this is something you have to put on evidence for to support, it's really a bad idea generally to do this kind of defense. Even if you were a saint, unfortunately, there would probably be members of the community that would say that you're a false prophet or something like that. So, to sum up, using good character is a bad idea. any kind of character evidence generally is a bad idea, and it can become in some kind of nebulous ways. Like, let's say you're in a DUI trial and you say, well, I just don't trust the breathalyzer machines or things like that. And they can show where you've taken them before, or if you've made some kind of statements regarding DUIs in general, or you've done something that's inconsistent with that statement that now comes in. That's very damaging. It makes you look dishonest to the jury and makes it harder for you to get acquitted. So that's the second affirmative defense we've talked about today. If you have any questions, again, please feel free to call me at 899-6696. And again, this is regarding the law of Montana currently in 2021. It could change, obviously, at any point. What's allowed in and what's not can change, and this is for educational purposes only and not legal advice.